Dude, put the shit behind you. You have to. You want your daughter to have somebody else walk her down the aisle because she can't trust you and her mother to be in the same room at the same time without a problem? Do you want that? Then I don't care. I don't care. There is no his fault, her fault. There is none of that. You can't afford it. Obviously, your relationship fell apart, but at some point you loved each other enough to make 3 babies together. You don't want that for your children, do you? You got to remember that you love your kids more than you're mad at each other. You have to. Otherwise, you might as well both pick up extra jobs and start putting money aside for their therapy for the next 20 years. Don't do that to your kids. Don't do that to yourselves. I'm done. Go away. Raise your right hand for me. Do you swear or affirm tell the truth, the whole truth, nothing but the truth today?
Yes, I do.
Come on up here and watch your step. There's an incline ramp right here. It'll trip you if you're not ready for it. Settle in that chair right there. Get comfortable. State your name for the record.
My name is Kiana Harris.
Thank you. Go ahead, host.
Thank you, Judge. And I apologize. Just a motion to sequester all witnesses except for the OLC in this.
And look around. Anybody here that shouldn't be for a sequestration order?
I don't know.
Not that I suggest.
Okay. Proceed.
Thank you, Judge. Good afternoon, Mr. Harris. Do you recognize a Mr. I'm sorry. Give me 1 second.
Andre Harris.
Do you recognize an Andre Harris?
Yes, I do.
Can you please point to him and identify him by something he's wearing for the record?
Yes. That is a plain shirt and dark.
Noted for the record.
Thank you, Judge. And how do you know Mr. Harris?
I was married since
For how long?
12 years.
And where do you live?
I live in Belleville, Michigan.
And what is your address?
13218 Mansoff Court.
Okay, and is that in Wayne County?
Yes, it's Point County.
Okay, and did you live there on 1/29/2025?
Yes, I did.
Okay, and did anything out of the ordinary happen on it?
Yes, I did.
Why don't you tell us a little bit about that?
Okay. I was at home on the telephone with my family. She was like, around the 4 o'clock hour. My battery was going low, so I got up to get the charger. When I went to the building to get the charger, their cell phone was plugged into the charger, which was plugged into the wall. I unplugged the cell phone from the charger, and I disconnected the charger from the wall and plugged it into my cell phone, which was in my hand. I walked out of the bedroom and I was walking back into the loft to finish my conversation and to plug in the charger before the phone. In the midst of me walking out in the hallway into the loft, the stairs approached me aggressive and with some cuss words about the charger. So he went to grab the charger, which was in my hand with my phone, and he took my finger, trying to get my phone in my hand, and did my left hand back. I had the phone in my hand. The phone fell to the ground and we both tried to grab the phone, pick the phone up and threw it against the window. I tried to retrieve the phone again, threw it against the wall. After that, I just pushed me and went downstairs. Elbowed me outside. Elbowed me in the
Okay, and those contacts to your person, were those consented to? Did you consent him to
No.
bring your phones back? Okay.
No.
And after that, what happened?
After that, I called the police to let them know what was going on, and they let me know they had already received a phone call and they were en route to us.
Okay. Okay, and did they arrive?
Yes, they were.
And did you make contact with them?
Yes, when the police came, the door was open and I agreed with the police officer, sat at the side of the house, asked what happened, and I gave them the story. And he also gave me a statement, papers to write on the statement.
Okay. And was Mr. Harris there?
No,
Okay, I have no further questions from this witness. Thank you.
Ms. Taylor?
Ms. Harris, your testimony is that you got up to get the charger and my client's phone was plugged into it.
Yes,
Isn't it fair to say that when my client was coming up the stairs, you were laying at the top of the stairs?
yes, I was sitting at the top of.
To the fact where he had to step over you to get by you, was that correct?
No, we have a loft upstairs, so once you come upstairs, there's an open floor.
And that's the bedroom that the two of you shared during the marriage, correct?
The loft is the open loft, it's not included in the bedroom at all. The bedrooms are off to the side.
And so you would agree that this was Mr. Harris's charger?
No, it's not upstairs.
And so your testimony is this was your charger?
This is the charger for the home, so we have 3 iPhone chargers, which we all use. So that was my kid's never used the charger. So that's the charger that literally stays in the bedroom, that has been in the bedroom for over 2.
And isn't it fair that he asked for the charger?
No, he did not ask me for a charger.
Is it true that the two of you have a history where you called the police on Mr. Harris when you're upset?
Your Honor, now I'm gonna interrupt.
I have-
Hold on, Ms. Harris. Ms. Harris, when there's an objection, you can't talk.
Oh,
Objective relevance about any calls. And also this is 404B evidence that we have not noticed, so.
I'm not seeking to
Pick either way.
the evidence, it's just the credibility of the witness, and I'm not even asking for the substance of those prior calls, just whether she has called in the past.
I'll allow it.
I have never called the police on under unless it has physical contact. So a push, a shove, a hit. So the things where I call.
And so that would be, yes, you called the police in the past.
When there has been physical
Yes,
touch, correct.
and it's also fair to say that the two of you recently went through a divorce, correct?
Yes,
And would you agree that that was a contentious process?
yes,
And as part of that divorce, the marital home, which is the home that you were at on the date in question, is being sold, is that correct?
the house is sold,
So that is correct.
yes,
And you are to vacate the home by the 28th, is that correct?
correct.
And so, when you had interactions with law enforcement on this night in question, is it fair that they asked you if you wanted to move forward?
Yes, it is,
And you told them that you're in fear for your life?
correct.
But isn't it true that since that incident, you've attempted to reach out to Mr. Harris?
Yes, I have.
So you're not in fear for your life to the point that you don't want to contact him?
I reached out to Mr. Harris for his children because we have 50-50 custody. And I was told that I can reach out to Mr. Harris so we continue the court order that the judge stated in our divorce. So we're supposed to be 50-50. Mr. Harris has not came and kept the kids only for 1 weekend and then the following day. So I also reached out to him to say, hey, Mr. Harris, after he sent a meeting that had nothing to do with the children to me, I was finding back with when you see your children, when you get your children haircuts.
Well,
I was never under the impression that there was no contact where I couldn't contact him as far as the kids.
speaking of that meeting was sent in 2024 though, correct?
That meeting was sent on February the 18th of this year.
And so a subpoena of Facebook or Instagram would show that that meeting was not sent in the year 2024.
Yes, I have it on my phone now.
And you admit that you contacted Mr. Harris through social media.
Right after he contacted me with the meeting, my response was, when can your kids get their haircut?
These are yes or no. So you
Yes.
contacted him through social media.
After I was contacted, yes.
And your testimony is that you contacted him for the children. You were upset that Mr. Harris wasn't coming to the home for parenting time, correct?
No, that's incorrect. I was never upset. My kids would like to see their father, they're used to their father in their lives. And we have a court order. So I would like for him to be able to see the kids and keep them on the days that he is the great work that he's supposed to keep the kids, so.
And when you say see the kids, you mean you would like him to come to the marital home to see the kids?
No, I was told that he cannot come to the home, he can only contact me for parental, anything about, he can only contact me when it's time to drop the kids off or when it's time to pick the kids up.
And you would agree that Mr. Harris is a good father, correct?
No, I'm not agree. In the past, yes, I'm seeing a different side of him now where I can't actually say I agree with that.
Yes, but the fear that you testify that you have, you obviously don't have that fear with children.
I'm
right?
here for my life, not for the kids, so. I would never fear for the kids with a child.
Nothing further.
Okay.
Any redirect of this witness?
Um,
Ma'am, you can step down. Step on that one. Next witness, Mr. Lucky.
People call, Officer Stanton.
Thanks, Ken. Officer, come on up front. Raise your right hand. You swear affirm, tell the truth, the whole truth, nothing but the truth?
I do.
Come on up. Have a seat. Settle in, watch the ramp. Get comfortable, state your name.
Name is Jeffrey Stanton.
Thank you. Go ahead, Ms. Vanderneck.
Thank you, Judge. Good afternoon, officer.
Good afternoon.
And I'm so sorry, what was your rank?
Sergeant.
Sergeant. Good afternoon, Sergeant Stanton. Sergeant Stanton, what is your current occupation?
I'm a patrol supervisor with the Van Buren Township Police Department.
Okay, how long have you been with the Van Buren Township Police Department?
17 years.
What training did you receive to become a police officer with Van Buren Township?
Went through the standard police, basic police academy, and then numerous trainings throughout the last 17 years.
Okay, thank you. And I'm gonna take you back to, and can you explain what your duties include in your current position?
Duties include supervising a platoon of 6 officers. That's administrative and patrol duties. I also patrol as well.
Okay, I'm going to take you back to January 29th, 2025. What were you doing that day?
I was on patrol.
Okay, did you have a partner?
No,
Did you receive a call to 13218 Manitowoc Court in Belleville, Michigan?
yes, it's a Belleville address, Belleville mailing address, but it's in Van Buren Township.
Okay, and that's in the county of Wayne?
Yes.
Okay. What happened after you received, or what type of call did you receive regarding that address?
The call was for a civil standby. Somebody called stating that they wanted to retrieve property from the residents.
Okay. Do you know who called?
Mr. Harris.
Okay. And what happened next?
While I was driving there, Officer Champagne got to the location first. And dispatch advised that Mr. Harris called to cancel, saying that he wasn't gonna go to the residence. That's.
Okay. What happened next?
Officer Champagne advised that there was a domestic violence situation that happened previous, that Mr. Harris was the suspect.
Okay. And what did you do after you received that information?
Officer Champagne, I was still continuing to the address. Officer Champagne advised that Mr. Harris was driving a, I believe he called it a Cadillac truck, which we later found out was a Cadillac Escalade, gold or champagne in color.
Okay. And did you have any contact with Mr. Harris on that day?
Yes, the Cadillac Escalade passed me. I got behind it, I ran the license plate, and I came back to the victim. And I made a traffic stop on the vehicle.
And I'm sorry, who is the victim?
I don't know how to pronounce the first name. It's Kianta Harris. I don't want to misspell or mispronounce her name.
Thank you. And what did you do next?
I made a traffic stop on the vehicle. I placed Mr. Harris under arrest for domestic violence. He was placed in the rear of my vehicle.
Did he make any statements to you while you were arresting him? If you recall?
No, I don't recall specifically.
Okay. When he was, did he ask you to retrieve any property for him from the car?
Yes, I advised him I was going to turn the vehicle over to the registered owner and asked if he would like any property out, any of his property out of the vehicle before I turned it over to him. He requested a backpack instead of keys.
Okay, and where was the backpack? In the car?
In the second row seat, right behind the center console.
Okay, right behind the center console, you said?
Yes.
Okay, can you describe the backpack?
It was just a backpack,
Okay,
black, and it was multi, had a couple of colors, so.
What type of material was it made of?
Nylon.
Okay. And what happened next?
I recovered the backpack and the set of keys from the car first, which was, and prior to putting the items into my patrol car, I inventoried them.
Oh, how, what happened when you inventoried the items?
In the main compartment of the backpack, I found a 9mm Taurus handgun. And then in a separate, that handgun was unloaded at that time. And then in a separate compartment in the backpack, I found a magazine containing 9mm ammunition.
Okay, and I'm sorry, you said the magazine contained 9mm ammunition?
Yes, I believe it was 12 rounds in that magazine.
Okay. Where in the backpack, if you recall, was the 9mm?
In the main compartment,
Okay, and where was the magazine, the ammunition?
in a separate compartment that had another zipper directly adjacent to the main compartment.
Okay. I'm sorry, you said directly adjacent to the main compartment?
Yes.
Did defendant tell you that there was a firearm in the backpack?
No,
Sorry, did I ask for just a brief indulgence? And what did you do when you found the firearm?
I rendered it safe and collected it as evidence. It was like a package and it was transported to the police station where it was packaged and secured in the proper locker.
Do you know if defendant had a CPL at the time?
I did run Mr. Harris through linking to check for CPL status and it said that he was disqualified.
Okay. Thank you. And just to back up a little bit, you said that you found the backpack in the defendant was in the driver's seat of the vehicle
Correct.
of an Escalade. And you said that the backpack was directly behind the center console.
Yeah, so not directly, it was on the floor of the second row seating. So it wasn't directly behind the driver's seat, it was kind of in the middle of the driver and front passenger, like directly behind the center console.
Okay, thank you. And Judge, I would just like the record to reflect that when the sergeant was describing where the firearm was, he did gesture with his right hand behind him to the right.
I would object that that gesture indicates any type of proximity because the officer just testified not directly behind.
I'll take judicial notice if I know where a console is and I know where a second row seat is.
Thank you, Your Honor.
Your witness, Mr. Taylor.
Oh, I'm sorry, just a moment.
Sure.
Your Honor, I have no further questions.
Thank you. Now your witness, Ms. Taylor.
Sergeant, on that day that you arrived, were you with a partner?
No.
And are you aware that Mr. Harris had also called law enforcement that day?
Yes, that's the call, responding to was when he called.
Okay, so you were responding to his call, not Mrs. Harris.
Correct.
And do you know what the reason for his call was?
To retrieve property.
Okay. And was there any direction or advice provided by law enforcement with respect to his question to retrieve property?
Don't understand trades.
So did anyone say, yes, you can go back to the home to retrieve your property?
The plan was to do a civil standby where we go with him to retrieve property.
And so initially, was the plan to arrest Mr. Harris for domestic violence or just to go there for a civil standby?
I was just going there for a civil standby at that point.
So at what point did it turn from a civil standby to an arrest for domestic violence?
Officer Champagne spoke to somebody at the residence, Ms. Harris, and she advised that there was some sort of domestic violence assault that occurred where Mr. Harris was the suspect in.
Okay, and are you aware if there were any injuries or ambulance called?
No, there was no ambulance call. I know that. I don't believe there was any injuries, no.
Any photographs of anything?
No. Not of injuries.
And when you effectuated the stop of Mr. Harris, was he cooperative?
Yes.
And he was immediately placed under arrest for domestic violence?
I spoke with him for a couple of moments, given our position and where he was on the entrance ramp to the highway. I waited for another officer to arrive before we took him into custody.
And when you went back into the vehicle at that point to get the book bag, was that upon the request of Mr. Harris, or were you just doing a search of the vehicle?
It was upon his request. I asked if he wanted any property retrieved from the vehicle before, any of his property retrieved from the vehicle before it was turned over to somebody else.
And was there any other search of the vehicle outside of that?
No, I just recovered the property that he asked for.
And you said that was on the floor of the second row?
Yes.
And the firearm was inside of the main compartment of the backpack, is that correct?
Yes.
Separated from the magazine?
Yes, ma'am.
All right, nothing further.
Any redirect?
No, you're right.
Sergeant, you step down.
Thank you.
Watch your step, be safe. Can we send the sergeant back to his duties?
Yes, Your Honor.
Thank you,
Thank you, Your Honor.
appreciate it. Any other witnesses from the people?
No, you're right.
Any defense witnesses?
No, Your Honor.
I'm ready for argument.
Your Honor, at this time, I move to bind over on all counts and reserve argument.
Thank you.
Your Honor, I would like to draw the court's attention to People versus Nimitz, NIMETH. The site for that is 36 Mishap 616. It is a 1999 case. Judge, with respect to the CCW, this case is to support a conviction for carrying a weapon in a vehicle. The prosecution must show presence of a weapon in a vehicle operated or occupied by the defendant. 2, the defendant knew or was aware of its presence. And 3, that he was carrying it. Your Honor, it's an interesting case. With respect to that third point, carrying, it cites to another case, People v. Adams, but the proposition here is that there is sufficient evidence in the record to establish that the defendant was carrying the weapon at the time of his arrest when there's evidence presented that the defendant had access to the gun. And so this is the point that I hone in on, Your Honor. Under People v. King, as the court knows, the people have the burden of showing evidence on each element. And so here, based upon the limited testimony of the sergeant, there's simply no evidence to show that my client was carrying it under the legal interpretation of carrying with what we have here on this record. The sergeant clarified, even when Madam Prosecutor tried to say with her hand, making it in hand distance, he said not directly behind. That was the direct quote of the sergeant. And so here, Your Honor, we would contend that this evidence on the record, under this third element, my client was not carrying. That book bag was not in reasonable access of the defendant. And here, Your Honor, in this Nimitz case, there was evidence here because the weapon was lodged right by the right side of where the defendant was, within arm's reach. And so Madam Prosecutor never asked the sergeant, Judge, is this weapon within arm's reach? Because then that would have been evidence on this record for probable cause to show that my client was carrying it. But the clarification that the sergeant said not directly behind, it falls short. It falls short. And under this case, which is published case law in this state, Your Honor, the people cannot satisfy that third element of carrying to show that my client had access to it. And so we're asking that it did not be bound over on this count, Judge.
Thank you. Response.
Thank you, Your Honor. In this case, I believe that the elements have been met, specifically the element that defendant possessed the weapon while he carried the weapon while he was in the vehicle. According to People v. Emory, MVRY 150, Mishap 657. This is a 1986 case. Factors to be considered in determining whether the defendant carried the weapon in the vehicle include defendant's awareness of the weapon, the accessibility or proximity of the weapon to the person of the defendant, defendant's possession of items which connect him to the weapon, such as ammunition, defendant's ownership or operation of the vehicle, the length of time during which the defendant drove or occupied the vehicle, and the nature and extent of defendant's previous contact with the firearm. In this case, regarding the second factor, the accessibility or proximity of the weapon to the person of the defendant, I assert that because, well, number one, defendant knew the weapon was in the car, he asked the officers for his backpack. The officers or the Sergeant Stanton testified that the pistol was in the backpack, and although it was unloaded, a loaded magazine was in a compartment right next to the compartment of the backpack where, the pistol was found. This was a soft-sided backpack. This wasn't like a gun case. There was no safety, I forget the name of it, I'm sorry, the red safety lock in the pistol.
Trigger lock,
I'm sorry?
trigger lock.
Thank you, Your Honor. I would argue that I assert that the backpack was in the defendant's wingspan. He may have had to lean over a little bit to get it, but all he had to do was lean over, grab the backpack. He could have easily unzipped it and loaded the clip into the firearm. Defendant was driving the vehicle at the time. And he knew that it was that the firearm was in the vehicle. Just a moment.
Sure.
Oh, and of course, he didn't have a CPL judge. Additionally, Your Honor, defendant had constructive possession of the firearm because he knew where the firearm was, and factors for constructive possession, as the court knows, our defendant knew where the firearm was. If it's in the lockbox, does the defendant know the code or have a key to the lockbox? In this case, it wasn't even locked. It was just a zipper. Defendant knew it was there. So I argue that the people have established by probable cause that defendant possessed the firearm and carried the firearm.
Your Honor, may I?
Briefly.
Just going towards the case that Madam Prosecutor cited, Judge, that this case does not support her position. In fact, it says in the present case, they looked at a combination of factors. First, defendant was seated in the rear seat on the right side of the vehicle with a styrofoam box on the back window directly next to him. Defendant's proximity to the gun therefore provides some circumstantial evidence, Judge, so it wasn't just that he was an individual carrying the gun. The fact that another passenger was just as close to the gun as defendant tends to affect the weight given to that factor. This case does not support Madam Prosecutor, Judge, because it's still, you have to have proximity. And those questions were not fleshed out with the sergeant. And so what we have on this record and what the sergeant testified to, we don't have anything to say proximity. And there's no case that Madam Prosecutor is going to cite that's saying the constructive possession in this context in a vehicle, Judge. So based on the case law that I have cited to this court, and even Madam Prosecutor's case that she wants to rely on, it still supports us in dismissing the CCW count, Your Honor, because there's no hearing.
Thank you. It's a probable cause hearing. I heard enough testimony for proximity because it was in the second row. I'd say if it was in the middle of the seat, it was more accessible than if it was directly behind the driver's seat. I don't even have to get into the fact that your client's a tall guy with long arms. I can't even picture a passenger vehicle that's commonly sold in this country that the driver couldn't reach the floor of the back seat without contorting him or herself. I'm going to bind over. Trier fact might have a different opinion. AOI date is going to be the 2nd of April, 9 a.m. Bond is continued. I wish you luck downtown.
Your Honor, we have one other thing to take care of. We're seeking to do a motion to amend his bond conditions. I represent Mr. Harris in the divorce. The marital home was sold. They have to be out by March 28th. And so we've tried to effectuate this, but he has a moving company that is coming out on Sunday at Saturday at 1:30, Your Honor. And so we need to modify the conditions because he needs to be able to get in there Saturday, but also Friday before to pack some things up. So we're looking to get a few hours on Friday where he can box things up, and then a few hours Saturday, so the moving company can come because he has not been back in the home since this happened.
All right. So the condition we're talking about modify is a not return to the address.
Exactly.
Your Honor, we also would like to make our own bond modification.
Let's do one at a time. Let's talk about the not to return to.
So, I believe that position is between the defendant and the court and the defendant and the police officers. We, at the prosecutor's office, cannot make any recommendation.
No position on that. Okay. What do you want to change?
We heard testimony that there was some contact in between in violation of the no contact order set by this court on the arraignment date, that occurred on February 18th at 12:06 a.m., which is in violation of this court's no contact order.
Your Honor, may I?
Not yet. I want to review the ROA. Okay, go ahead, Ms. Taylor.
Your Honor, I previously dealt with this with Mrs. Harris's former counsel. As this court knows, that when you respond to something on a thread that the parties have, there may be something above it. Your Honor, the meme that Mrs. Harris refers to was sent last year when this case wasn't even active. So Judge, there was no violation. And if anything, Mrs. Harris is trying to create these traps and situations to set my client up because she was the one who reached out to him. He hasn't reached out to her at all. He has not violated any orders of this court to reach out to her. So she reached out to him through, I believe it's Instagram or Facebook Messenger, not the other way around, Judge. And she responded on a thread that they had already had from during their marriage messaging each other. There's no bond violation.
And Your Honor, I may apologize. The people can, take more testimony if we need to. However, I don't think.
No, you can't. No, you can't.
Merely asking that you just remind the parties of what no contact means.
Oh, I'm going to do better than that. Is she still in here? Get her in here. All right, so that's the bond. I'm leaving the bond as is. I'm going to allow Mr. Harris and or his moving crew access to the home on the 21st, Friday. Give me a 3-hour window when you can be there. 12 to 3?
12 to 3.
All right. And give me a window of when your crew's going to be there Saturday.
1:30. So it all depends on how long it takes them to move. The Friday, I just want to go and pack up some stuff.
Understood. So if Saturday, the window is from 1 p.m. to 6 p.m.
Should be enough time.
Thank you.
All right. All right. You can have a seat. All right. I'm gonna, first of all, I think I did all the official stuff. Bound over, gave you the OA. We're all done there. Okay. All right. So this is unofficial. How many kids do you have, Mr. Harris?
3 children.
All right.
3 children of my own and raised her son.
Okay. All right. So you guys don't have any minor kids together?
Yes.
Do or don't?
My children together.
That are, okay. You're the dad, she's the mom. Okay. How old is the youngest?
Youngest is 6.
Okay. And how old is the oldest?
12 in October.
Okay. There is no way for me to say this without being offensive. So I will apologize for any offense I give, but I'm not going to apologize for what I say. You two have to stop. You owe it to these kids to figure out how you can treat each other as nice as you treat the Starbucks barista. You have to. You got daughters?
One daughter, yes.
How old is your daughter?
Daughter's 11.
Can you picture her wedding day?
I tried to. I just found out some recent news that her mom has been hiding from me recently. So
You're doing it. You're doing it. Dude, put the shit behind you. You have to. You want your daughter to have somebody else walk her down the aisle because she can't trust you and her mother to be in the same room at the same time without a problem? Do you want that?
I don't know.
Then you got, I don't care. I don't care. There is no his fault, her fault. There is none of that. You can't afford it. Obviously, your relationship fell apart, but at some point you loved each other enough to make 3 babies together. You have to figure out a way to go forward for those kids. I'm not asking you to meet weekly for coffee and chat. I'm asking you to treat each other as kindly as you would a stranger that you saw in a store. If you do that, your kids will never have to choose who gets to go to a school function. You don't want that for your children, do you? You got to remember that you love your kids more than you're mad at each other. You have to. Otherwise, you might as well both pick up extra jobs and start putting money aside for their therapy for the next 20 years. Don't do that to your kids. Don't do that to yourselves. I'm done. Go away.
Thank you.
Thank you, Judge.
Are we ready on bails?
Ready on bails, Your Honor. I was going to confer with Ms. Mandernash about another case, Reynolds, that at the same time.
Go ahead. Lipke a special prosecutor?
No, never.
Liv-
Mr. Whittier's out in the hallway, but Mrs. Mack.
Okay. So, all right, Patricia's got all the rest of them now?
That fails.
Bales of Holly? Oh. What's your name? Are we ready on bails?
It's just people are.
That's ready. I don't believe my other client's case would take very long. I believe it's about to be a dismissal, so.
Yeah, let's try to get it out of the way. That's Reynolds.
That's Ms. Mandernash.
Reynolds.
Reynolds, yes.
Can you see if Patricia can come in on Reynolds? What's our docket look like tomorrow?
Big. The whole entire box.
Okay. We got anything in the afternoon?
Good morning, June.
Oh, yeah, we got meetings all day. Yeah, we got meetings all day. Yeah. All right, can I call Reynolds?
Is Your Honor.
Appearances?
Just. I just want to, I don't think my officers are here, I just want to run.
Didn't ask me to do anything.
Perkins in my home.
Did you get anybody about our meeting tomorrow with the victim benefit?
Thank you for allowing me to go out and check. I confirm that none of the officers that I have subpoenaed are present. It's my understanding that complaining witness in this case is deceased. I am unable to proceed without the officers.
Your Honor, given that the people are unable to proceed the case against Mr. Jeffrey Reynolds, my client, I would ask the court to dismiss the charge.
Dismissed without prejudice. But. No cash bond. You're all set.
Thank you, Your Honor.
All right, now we're ready on bails,
Yes, Lord.
appearances.
Good
Yeah,
afternoon. Asking now requesting permission under MCR 8.120 to conduct this hearing. I am a recent graduate at the University of Detroit Mercy School of Law, awaiting bar results, and I'm under the supervision of Attorney Mohammed.
Good luck. Granted, but I didn't catch your last name.
Asmaro, Asmaro.
And of course, no objection from the defense to Ms. Morrow practicing.
Thank you. Thank you. Sit, make yourselves comfortable. Let's call a witness. Pardon? Yeah, yeah. Let's call a witness.
Judge, we just have one preliminary bottom report.
Go ahead.
People are looking to admit people's proposed exhibits 1, 2, and 3, and 3rd pursuant to MCL 766.11B.
I believe, yeah, this is referring to preliminary drug analysis, no objection to their admission for exam purposes only. Thank you.
Appreciate the stipulation. 1, 2, and 3 will be admitted. Have you marked them yet?
And good morning, or good afternoon, Your Honor, Mohammed on behalf of the people. We're not moving to introduce it under 76611, but my understanding is it. It doesn't.
You stipulated, didn't you, Mr. Martin? Or no objection?
There's no objection. That's
Okay.
what I'm saying.
All right,
Thank you.
but we need
But
the exhibits up here so we can mark them.
not under that.
Got it. Now can we call a witness?
Yes, Judge.
Who's first?
I apologize, one preliminary matter. You did a mutual order of sequestration with the exception of the officer.
I think there's nobody here that doesn't belong here, so we're good. Yes, was the answer to the question.
And people do call officer and the rest of the stand.
Who was the officer? Perez. Officer, come on up front, watch your step on my incline ramp, raise your right hand as you walk up. Do you swear or affirm, tell the truth, the whole truth, and nothing but the truth today?
Yes.
Settle in. Get comfortable, state your name.
Officer David Gross.
Thank you. Go ahead, counsel.
Officer Perez, are you currently employed?
Yes.
Where are you employed at?
Van Buren Township Police Department.
Are you a police officer?
Yes.
How long have you been a police officer?
17 years.
And were you a police officer on the date of February 1st, 2025?
Yes.
And did your duties as a police officer take you out near the location 6119 Rawsonville Road?
Yes.
Is that in Van Buren Township, County of Wayne?
Yes.
Okay, what brought you to that location?
I was at a routine patrol in the area that was a plaza.
Were you alone or with a partner?
I was alone in my sweater.
Okay, and were you, was the scout car marked, the mark?
Yes.
Was it fully or question marked?
Fully marked in your township patrol car.
And were you in uniform?
Yes.
Was it full or modified?
Full. Whatever.
And while on patrol, what if anything did you observe that brings you to court today?
I was sitting in the parking lot, I observed the red Hummer H3 SUV towing a trailer. That I go with.
Okay, and what was significant about this?
That vehicle is known for past contacts that I've had with all of our agency. With the owner being Mr. Lee Bales.
And are you familiar with this individual?
Yes.
And was this individual present by the vehicle or was he there?
Yeah, shortly after, several minutes later, seeing a male subject walking away from the area of that vehicle.
Okay, what did you do when you saw this individual?
I proceeded to drive towards that individual,
Why were you driving towards him?
to identify him. I ran Mr. Bales through Lee and discovered that he had several major township Martinsburg arrests, as well as a big township.
And did you make contact?
I did,
And did you see that individual in his courtroom today?
yes.
Could you please point out and identify an article of clothing that they are?
Gentleman over here, in the green top,
Noted.
Judge,
You're welcome.
you say that you made contact with the defendant. What happened when you made contact?
I approached him with my patrol car, I turned on the activated one of my lights, told him to stop, with a bag of meat. I didn't know Mr. Bales burned it, as one on the scene.
Okay, did he stop?
Yes,
And what happened after he stopped?
he was carrying a couple personal, smaller style carrying bags and a 2 liter soda.
How many bags was he carrying? Okay, and what happened after?
He set down the bags of soda on the pavement and proceeded to walk toward me at
Okay,
the front.
and what happened when you walked towards you?
I invited him to get a warrant for the arrest. And I took him into custody for the warrants.
Okay, so you placed him under arrest. What happened after you placed him under arrest?
I performed a search of the person and his belongings.
And did you recover anything?
Yes, in his front left coat pocket, for his last bite, kind of his very small, right, that
Okay, and then stated that you also was carrying bags with him. Did you conduct a search of the bags?
Yes, the one bag that he had with him, they set down a black bag. I searched that bag. And within the contents that I discovered a rectangular plastic storage container.
And did you check what was in, did you see what was in that container?
Yes, I opened up that compartment, that rectangular container, and inside was a clear plastic baggie that had suspected methamphetamine.
Okay, and what did you do with this item that you recovered?
I took possession of it.
Okay, did you place it into evidence?
Yes.
And do you remember what the evidence bag number was?
It's the case number and evidence item number 1.
Okay, and was it placed in a evidence locker?
Yes, I put it into evidence locker number 3.
Okay, and were you provided with the evidence tag number?
Yes,
Okay, and do you remember that number?
I don't remember the whole number.
Would it refresh your recollection to do the report?
Yes.
Judge, may I approach?
Certainly.
Just take a look at that document and whenever your memory has been refreshed, please look up and I can re-ask the questions. Okay, what was the evidence tag number?
25001187.001.
And judge, for the record, he did read off the report.
Noted.
Okay, and then after this was placed in evidence, what, anything happened after?
Mr. Bales was pending warrant smell. The case was turned over to the detective.
Nothing further.
Mr. Martin, your witness.
Good afternoon, Officer Perez. Just a few questions for you, sir. So. When did you perform this lien search on Mr. Bales? Was that before you had spoken with him?
Yes, sir.
Okay, and what did you have a name at that point already that you ran for the lien, or were you running the vehicle?
I ran it.
Ran the name. And what was the source of your knowledge of the name?
The red H3 Hummer trailer attached with it. Some significant markers on this vehicle that I've seen before.
So from your personal knowledge and recollection, you saw the vehicle and knew the name associated with the vehicle and just ran it that way?
Yes, sir.
Okay. And he said that when you called out to Mr. Bales to stop and he did so, he was walking towards something.
He was in the storage lot. It's like a used storage lot. That's where I made contact with him.
Okay, so did it appear to you as if he was walking towards a storage locker that might have been his?
It was still like the pavement parking lot area. He had made it to a specific storage unit or anything.
Okay, but he was parked at the storage facility transporting his bags, correct?
I'm sorry, definitely been mistaken. He was parked at the plaza lot. And he walked across the street towards the storage lot, was where he got it.
Okay, I see. And you weren't attempting to search any storage unit belonging to him, were you?
No.
And you noted that you had found a pipe of some kind in his coat pocket. That pipe looked new, right? Looked unused.
I believe there's a photograph attached to the report, I don't have it, but I don't recall if it looked brand new or whatnot.
Okay, would looking at that photograph refresh your recollection about the pipe's appearance?
Yes.
Just one moment. Your Honor,
Sure.
Officer Perez, does that look like an accurate photograph of the item taken from Mr. Bales's pocket?
Yes.
Would you agree that that pipe looks unused?
Yes.
And so there was no residue on the pipe that you could test, right? Or no the preliminary exams that were conducted had nothing to do with this pipe.
I didn't conduct any preliminaries myself, but
To your knowledge, nothing off this pipe was ever tested.
correct.
And then you described a plastic black case in which suspected drugs were found.
Yes.
And that was, so you found this case, and before you open the case, you can't see what's inside, right?
Correct.
There's no odor or anything from the case.
No.
And the case itself was inside a bag that Mr. Bales had placed down?
Yes.
And was there anything else in that bag?
Several things, all kinds of different belongings.
So you,
Miscellaneous items.
thank you. So you had to presumably remove several items from this bag before discovering this little black case.
Yes.
And so safe to say, if you had just picked up the bag and carried with it, you would have no idea that it contained these suspected drugs. Fair enough?
Okay.
And there were no suspected drugs that were found on Mr. Bales's person, just in this bag.
Correct.
And you didn't note any signs of drug intoxication on Mr. Bales's part, did you?
No.
You didn't perform any field sobriety tests on him?
No.
And you're not aware of any urine analysis that you?
No.
Just a moment.
Sure.
Nothing further, thank you, Judge.
Any follow-up? You're all set, Officer Perez. Thank you. Any other witnesses, counsel?
Your Honor, for us.
Any defense witnesses?
Sorry, Your Honor.
Defense witnesses? I'm ready for argument.
Judge, the people are moving to. The people are moving to write over on count one possession based on the testimony provided by Officer Perez. Officer Perez stated that he was patrolling the area when he discovered an individual he recognized to be Mr. Bales. After recognizing this individual.
Let me stop you. Shame on you because you didn't teach her this. You don't have to tell me what I just heard. Some judges, you have to do that. This judge, you don't. So here's what I like to hear from my prosecutors. I'll reserve argument until I hear what the defense comes up with.
I apologize.
That's all right. It's not your fault. It's his.
My fault.
The defense is gonna come up with much, but I'm objecting to bind over simply with that argument. I understand this question back to you. Thank you.
It certainly is a question of fact. See, you saved yourself the argument. All right. I'm going to bind you over, sir. Your arraignment on information date is going to be next Wednesday at 9 a.m. I'll continue bond unless I hear something quick. Didn't. So bond is continued. I wish you luck downtown.
Your Honor, before you go off the record, just one.
Yeah.
I did tell Mr. Mohammed about this before, I believe he has no objection. I'd like the court. I'd like to ask Your Honor to sign an order that would require Wayne County Sheriffs to ensure Mr. Bales can call the drug treatment hotline, the Detroit Wayne Integrated Health Network hotline. We need a special.
Yeah. Is he in custody just on this?
He's serving a 90-day sentence
On what?
on a probation.
Where at?
Wayne
Okay.
County. The update is April 6th.
Do you have the order?
I can email it right now to.
Email it to Heather. Have you seen it? All right.
I did discuss it orally with the defense counsel. And just had no objection to the defendant.
I just want to make sure you say you have no objections to the order. So when Heather gives it to me, I'm going to sign it and we're going to get you out of here.
It says, first order, bond continued, and then the here it says, Wayne County Jail shall ensure WIHN. Yes, I.
Oh,
That's it. We'll get you order as soon as Heather gets a chance to go print it.
Thank you, Judge.
Steve, everything good?
yeah, how's your trip?
Here's what short version. The trip was fantastic. The travel to and from. On the way there it was problematic. On the way back it was nightmarish. But the trip itself was great.
Julie's going to next month.
Well, I've been told that my problems were not as a result of the region. It was just bad luck. So I'm hoping that's true. Mr. Woodyard, are you ready?
Yes.
Yep.
We wrote down.
Are we holding? Okay.
In this intense preliminary hearing, the court tackles two major issues: a CCW firearm charge and a separate drug arrest case. In the first matter, the defense argues the gun found inside a backpack on the second-row floor of an Escalade was not within immediate reach, claiming there's no proof the defendant was carrying it under Michigan law. The prosecutor counters that the defendant knew the gun was there, requested the bag, and could easily access it, making it constructive possession. The judge ultimately rules there is enough probable cause and binds the case over for trial. In the second case, an officer testifies about spotting a known suspect, confirming outstanding warrants, and recovering suspected narcotics from a container inside a bag the defendant was carrying. Evidence tags and lab analysis were introduced without objection, moving the case forward. Do you think the proximity of the firearm was enough to justify the charge, or should it have been dismissed? Drop your thoughts below. Like, share, and subscribe for more real courtroom breakdown.